4:08. Welcome back to Sunrise. Today we're continuing our focus on this Rivers NJC matter. But now we're joined by Ikechukwu Ikeji, who is a legal practitioner. Thank you for coming on this morning.
Thank you so much, Chamberlain.
Well, so much predicated on law about this entire matter. We've heard Honorable Golden Choma saying, look, the NJC has got to just respect the law, and that's where they are at this moment. Do you share the same view?
Well, I share the view to the extent that the NJC should respect the law. And I also share the view that what the NJC is doing is very much within the law. So it depends on the angle that you want to say the law is speaking from.
Let's take it from where he spoke about the court judgment.
Yes.
He was just relying heavily on that court judgment, saying, look, the court has said it. The NJC cannot, maybe if I could paraphrase it, force down their candidates on the governor, and that the governor cannot just pander to the whims and caprices of the NJC.
Yes, from what is available in the public space, and you will permit me to act according to, or to speak according to what we have seen in the public space. We know that that judgment was a declaratory judgment. And being a declaratory judgment, it is subject to appeal, but it does not. It does not. It's not. It does not give right. It does not award some element of right that you can equate with proprietary right, as it were. Now, what do I mean? When the Federal High Court declared that the NJC, I don't know what the Federal High Court declared, but I'm presuming that it declared that the NJC ought to have appointed somebody else, or ought to have recommended somebody else. It is a declaration. Now, what ought to have happened, in my view, was that the governor ought to have reverted to the NJC.
When? After the judgment?
After the judgment, as soon as the governor is dissatisfied with the recommendation of the NJC, and even post the judgment, the governor ought to have reverted back to the NJC. Because, you see, the appointment of a judge, or a chief judge, as it were, a judge is different. A judge has two legs, the NJC and the governor. But for chief judge, it has three legs on a tripod. You remove one tripod, it's an inchoate situation.
And
yes.
This one is the chief judge.
This one is the chief judge. There is no way the governor can appoint a chief judge without reference to the NJC. So even the court judgment would declare what it declared, and what the governor will now do, based upon the court judgment, is to revert back to NJC, right to NJC.
For what purpose?
That the recommendation has been rejected.
Are we also saying that the NJC wasn't a party to the suit? Because we would have thought that the NJC would have been aware of that court judgment and done what is proper.
No, you don't presume. What I don't know what the NJC, the thought pattern of the NJC, but I would expect that it should be in the public domain that the governor of Rivers State would have asked NJC to please give us another name, to please recommend another name. You can't, that portion, you cannot remove that portion. That portion is inviolable, if that is the language. The portion of recommendation, it is constitutional and has also been so decided by the Supreme Court in a particular matter involving the then Chief Justice of Kwara State and the NJC. And the Supreme Court was very clear in holding that the governor cannot appoint a chief judge without recourse to the recommendation of the NJC. That is the Supreme Court judgment. We also have the provision of the Constitution. So whatever the court decides, the court cannot say that the recommendation of the NJC shall be dispensed with. And I didn't think that that judgment said so. So a neutral observer should lend his or her voice to call on the executive to stop the reckless intrusion, to stop the executive incursion into the realm, into the arena of the judiciary. The very essence of the Montesquieuian principle and philosophy of separation of powers is to ensure that every arm of government acts independently. And it is more so where the judiciary is concerned. The judiciary is the bastion, is the last hope of the common man. So we should ensure that the judiciary is not fettered in any way whatsoever, even if we think that they are doing wrong. Even if we think that they are doing wrong, to an extent, even as lawyers, we owe it a duty to NJC to respect their viewpoint. And we can now go back. We can now go back and find a way to re-engineer the process within NJC. We have always criticized the process of appointments in NJC. But having said that, we know that there are problems in the structure. But that is not
in your own estimation, do you think, I mean, from what you have said now about
yes.
problems in the structure, do you think that it became a little too obvious in this particular process, in the sense that there were two names? The executive arm of government had to go to court over, you know, the rejection of one of the names,
yes.
and, you know, the appointment of the other judge. It would seem that after the process had gone to court and the results had come out from the court, or the judgment had come out from the court, there was only one option left.
You see, if it is within my authority, within my power to do a certain thing, and I so do such a thing, no matter the underlying intention that I have, it is within my power to do that. I have to be given that space to do that which belongs to me to do. So the fact of going behind to look at the intention of NJC does not arise. Even if you want to say that the NJC has a particular candidate in mind, it is within their powers to so recommend. And when the governor failed or refused to accept the appointment or the recommendation of the NJC, the simple thing for him to have done was to ask the NJC to go back and recommend. And take note that the State Judicial Service Commission...
Not to have gone to court?
Eh?
Not to have gone to court?
Not to have gone to court. And even where they have gone to court and got the judgment, it is still left for him to also revert to the NJC. Look at what the court has said. Even you were present when the court said it, that I shouldn't act on your recommendation. So NJC will go back within itself and come back again with another recommendation. But from the public space, from what we have in the public space, there is no such news that NJC was given the opportunity of coming back with a new name. And now, I want to make a very key point. And that key point is that the use of words in statutes is very important, and the interpretation thereto is also very important. In the third schedule of the 1999 Constitution, Part 1, which spoke about the Judicial Service Commission, what the Constitution said was the Judicial Service Commission, JSC, hereinafter, should advise, it used the word advise, the NJC. When it came to the NJC's portion, 271, it said recommend to the governor. Now, there are different levels of interpretation that you can put to the words advise and recommend. The Judicial Service Commission advises the NJC. It's an advice. And by the definition of advice, that means that you can go beyond the advice. You can go wider than the advice. But I'm not saying that the NJC went wider than the advice. I am saying that the purport...
In other words, you can choose to take the advice or not.
Or not. It. That is the purport of advice. But I'm not saying that the NJC didn't choose...
Doesn't that also apply to recommendation as well?
No, it doesn't. It doesn't, because what it says that the NJC shall recommend. It is recommendation. It is what is recommended to you that you will act upon. Yeah, and if you reject it, it is at the point of accepting that there may be a similarity. You are not obliged to accept it. And if you reject it, you revert to the person who had recommended that I reject your recommendation, and the person would come back. That's why it's a tripod. That tripod does not involve the Judicial Service Commission by any stretch of imagination.